With the enactment of these three parliamentary legislations, India is set for a significant overhaul of its criminal justice system. The Bharatiya Nyaya Samhita, the Bharatiya Nagrik Suraksha Samhita, and the Bharatiya Saksha Adhiniyam will, as we all know, replace the Indian Penal Code of 1860, the Code of Criminal Procedure of 1973, of course, which was preceded by the CRPC of 1898, and the Indian Evidence Act of 1872. These laws, in a sense, are a watershed moment for our society, because no law affects the day-to-day conduct of our society like the criminal law. Criminal law directs the moral arc of a nation and has the ability of depriving people of their cherished liberties as well. The underlying justification for the substantive provisions is the age-old harm principle, which is best summarized in the saying, "Your right to swing your arm ends just where the other man's nose begins." Procedural law, which governs crimes from the state of setting the criminal process in motion to the conviction for the commission of the offense, ensures that no person is charged and subsequently convicted for offenses without the due process of law. The one thing which was the striking aspect of our triad of criminal laws was their age, 1860, 1872, and even 1973. And I think the enactment of these laws by Parliament is a clear indicator that India is changing, India is on the move, and that India needs new legal instruments to deal with current challenges and the challenges which we envisage for the future of our society. The traditional harm principle found resonance with the understanding that crime is immoral. The father of criminology, Rafael Garofalo, defined crime as an immoral and harmful act that is regarded as criminal by public opinion because it is an injury to so much of the moral sense as is possessed by a community, a measure which is indispensable to the adaptation of the individual to society. The ideals underpinning the combination of harm and immorality are premised on the perception that deprivation of liberty leads to repentance and to moral salvation. There were two problems with this harm-linked approach to criminal jurisprudence. The first was that it is not a victim-oriented approach. The impact of the harm on the victim is not considered. Victims of crime often feel like their agency over their own decisions is lost by the commission of a crime. Our laws have therefore to aim to give victims a sense of agency and control in the criminal process, as well as a sense of justice. The second problem with the juristic foundations of our earlier laws was in regard to the harm and immorality approach, and that was that it advances a perpetrator perspective to crime, which views crime as an individual failing. It does not address systemic causes which push people to commit crimes. For example, a law addressing gender violence will rightly condemn such violence as immoral and punish it. But it does little to change the sexist and patriarchal approach and framework of our society, which induces the commissions of these crimes. Our laws needed to address these concerns and obviate age-old issues like delays in the examination of witnesses, delays in the conclusion of trials, the overcrowding of prisons, and the issue of under-trial prisoners. The 248th report of the Standing Committee of the Rajya Sabha on the Bharatiya Saksha Samhita of 10th November 2023 noted that the Indian criminal justice system has struggled to keep pace with the profound technological changes, our socio-economic milieu, and that these socio-economic changes have radically reimagined the way in which crimes manifest in society. The growing scope of technology and the new age crime which uses the digital landscape to create networks of collaborative units to commit crimes cannot be pinned to an investigative situs. Today's crime has no investigative situs, no physical situs. This has presented challenges in the investigation of crime, admission of evidence, and prosecution, as well as justice delivery. As a distinguished American jurist, Justice Oliver Wendell Holmes said, "In law in science and science in law, everyone instinctively recognizes that in these days, the justification of a law for us cannot be found in the fact that our fathers always have followed it. It must be found in some help which the law brings towards reaching a social end or a social purpose, which the governing power of the community has made up its mind that it wants." The newly enacted criminal laws have transitioned India's legal framework on criminal justice into a new age. Much needed improvements have been introduced to protect victim interests and carry out the investigation and prosecution of offenses efficiently. The BNSS encompasses a holistic approach to deal with crimes in the digital age. It prescribes audiovisual recording of search and seizures. For instance, in Section 105, and the presence of a forensic expert at the crime scene for offenses punishable with more than 7 years imprisonment, in Section 176(3). The audiovisual recording of search and seizures is an important tool for the prosecution as well as for protecting the civil liberties of citizens. Very often in courts, we hear sordid stories of what happens in the course of a search and seizure operation, particularly under the Income Tax Act. The judicial scrutiny would safeguard the rights of citizens against procedural impropriety during search and seizures. Similarly, the presence of a forensic expert at the scene of the crime, which enhance the efficiency of the investigating team and allow for crimes to be decoded with the aid of the latest advancements in forensic technology. While we make strides in this direction, we must now confront the challenges of fulfilling the aims of the new criminal legislation. Detailed rules need to be formulated on the type of devices to be used for recording, incorporating the principles of natural justice, and lay down the consequences of not carrying out such recordings. Since I took over as the Chief Justice of India, and even before that when I was the chairperson of the E-Committee of the Supreme Court, which I continue to be, I have advocated for creating a natively digital court infrastructure. We have strategically and persistently worked towards creating technologically equipped court systems which can facilitate a citizen-centric and efficient mechanism from the filing of a case to its disposal. Recently, the Government of India has sanctioned a budget of 7,000 crores for the Indian judiciary as part of the e-courts project. Our challenge was, in the first year, was that between November and 31st of March, we had to expend 850 crores to upgrade the hardware and software across India. I'm happy to inform you that we have been able to deploy hardware, software, and a whole list of technological changes covering 825 crores out of the 850 crores that were sanctioned for the first year. It was therefore very heartening to notice that Section 532 of the BNSS allows for all trials, inquiries, and proceedings under the code to be conducted electronically in Section 532. As laudable as this addition is, we must continuously introspect and protect the privacy of the accused as well as the victim when dealing with digitization of proceedings and creating digital evidence. In the digital age, the data and sensitive information of a person has gained paramount importance. This data can allow us to gain unparalleled efficiency and ease. However, the power which comes with personal data puts a corresponding duty to make systems which are immune to penetration and leakage of data. In the courts, we confront the challenges of data leak every single day. The safety of a person, the stigma attached to an accused, the threat perception of a witness will be compromised if the privacy of the stakeholders is not protected by us. We must inspire public confidence in securing the privacy of our citizens to gain an overall efficiency and trust in the criminal justice system. Technology holds the key to a futuristic court system. It eases the court procedures for the litigants, court staff, and the judges. In particular, clauses 3 and 4 of Section 532 of BNSS allow for the examination of witnesses and evidence through the electronic mode. The access ushered in by this provision will impact the access of witnesses to the courts and reduce delays in trials on account of the absence of witnesses. While the new criminal laws create provisions which are synchronized to our times, we must also ensure that the infrastructure accompanying these procedures are developed adequately for the country to reap the benefits of the new legislation. This naturally means that we must heavily invest in capacity building for our forensic experts, conduct training of investigating officers, and invest in our court system. Key provisions of the new criminal law would only produce a positive impact if these investments are made as soon as possible. Let us take the example of the timeline prescribed for the completion of trials and the pronouncement of judgments after the judgment is reserved. The BNSS provides that criminal trials must be completed in 3 years and that a judgment must be pronounced within 45 days of it being reserved. This stipulation is a breath of fresh air for addressing the issue of case pendency, as well as the rights of the victim and the accused in a criminal case. But if the court infrastructure and the prosecution lack material resources to harness technology and conduct an efficient and speedy trial, then the guarantees of the BNSS may run the risk of becoming merely directory and becoming unimplementable. Recently, in fact, just this morning, I've addressed a letter to all the Chief Justices of the High Courts, emphasizing that the Bureau for Police Research and Development has prepared a module for training and development for training of all stakeholders, including judges, public prosecutors, and others. All states in the country have their state judicial academies. On the part of the police, we have the police training academies. Now, it is important that we synchronize the training which is taking place in the state judicial academies, as well as the police training academy, particularly the one in Hyderabad, to ensure that we are able to synchronize our efforts and truly reap the benefits of the legislation which Parliament has introduced. Citizen-centric approaches have been adopted for supply of a copy of the first information report to the victim and to inform them about the progress of investigation, including by digital means. Additionally, the BNSS has made a positive development in protecting the fundamental rights of under-trial prisoners. Section 481 prescribes default bail for an accused who has undergone 1/3 of the term of punishment for the offense charged against him. This is a complete and radical alteration from the earlier provision or the earlier prescription under the CRPC. The BNSS prescribes that in cases where the punishment for the offense is 7 years or more, the victim shall be given an opportunity of being heard before the withdrawal of the case by the government. Summary trial has been made mandatory for petty and less serious offenses. The magisterial system has also been streamlined. One of the problems of our criminal justice administration is that we treat the serious and the petty almost on the same footing. That has to change, which it has changed under the new laws. But the real challenge is about changing mindsets on our part to adapt to the new system. Bearing in mind the evolving nature of crime and the emergence of new digital crime, it is imperative to boost the infrastructure and capacity of our police forces. Crime in contemporary times reflects the technological advancement of our age. Because of the inertia in the law, unfortunately, and the procedures governing investigation, our ability to hold criminals to account has been affected. Our attention must be focused on improving investigation by allowing for multidisciplinary investigation teams with law enforcement officers and domain experts in the field of cybercrime and pattern recognition. Technology must also be harnessed to improve the capacity of prosecutions and the court to work more efficiently. The prosecution can use technology to streamline paperwork and data to identify similar cases. This will enable the courts to streamline the listing process. The digitization of files and infrastructure for conducting witness examination online must be harnessed to record and peruse voluminous material with the swiftness of a tap on the screen. Our laws and their implementation are an ever-evolving area. There is no finality to any law or the manner of its implementation. However, we must be willing to embrace positive changes to meet the needs of our times. I expect that with the implementation of the new criminal laws, we will discover loopholes and areas which need to be addressed. Such debates would be helpful in enhancing the efficiency of our criminal justice administration. The ideological framework at the heart of our analysis must be justice-oriented, with a civil liberty-centric approach which balances the interests of the victim and the accused. The moral advantage of a criminal justice system in a democratic society is that it affords the victim an opportunity to reclaim their agency and confront an accused. It also lies in the fact that all persons, no matter how high or how low, would get full opportunity to defend themselves before a court of law. I hope that the various panel discussions in this conference spark a positive conversation on various aspects of the new criminal laws. These conversations are vital for our collective growth in an evolving legal landscape. As we look to the future, we must learn from our past and take its teachings with us. The new laws will be implemented by existing personnel. Now, that is going to pose a challenge for all of us, because these laws will call for a change in practice, a change in mindsets, new institutional arrangements, the re-engineering of our processes. We will have to strengthen existing structures. Let us not forget that while these new laws have been enacted recently by Parliament, our structures, our institutions, are robust institutions in a democratic framework. So we will have to build on the existing structures which we have and not discard them. And I would particularly like to highlight the importance of the use of e-filing, better litigation management by the use of existing tools such as the National Judicial Data Grid, the adoption of technology to bring knowledge and information to all stakeholders, the digitization of records, building on the interoperable criminal justice system, facilitating the adoption of speech-to-text transcription of evidence and judicial orders. In the Supreme Court of India, we have already started implementing the transcription of speech-to-text in important hearings before the Constitution bench. The E-Committee of the Supreme Court of India, in conjunction with the Department of Justice, has prepared a pilot model of transcription of speech-to-text. Now, this simple innovation will speed the process of recording evidence, of recording judicial orders, and ensuring speed in our process. Finally, I'd like to stress on the use of artificial intelligence. AI will enable us to track progress in criminal trials right from the stage of the FIR to the conclusion of the trial. We must deploy AI for the purpose of noticing aberrations in the process. When a trial is delayed, when witness testimony is delayed, AI will be able to flag for us red marks on why these delays are taking place, providing decision makers for supervisory control at all levels of the criminal justice administration, creating templates for simple orders and simple pleadings and simple filings. So technology today is replete with a world of opportunity for us. So it is not enough for us to only notice the radically new provisions of these 3 new legislations. A conference like this is important for us to educate ourselves about the changes which Parliament has brought about. But equally, we must focus on ourselves, because these new laws will be successful if we who are in charge of implementing these laws adapt to them, adapt to them not only in terms of our institutional process, but in terms of our mindset as well. As a very distinguished judge has said, the law is the witness and external deposit of our moral life. Its history is the history of the moral development of our civilization. And therefore, I hope that with this conference, all of you and all of us will be alive to both the challenges, the opportunities, and the duties which are cast upon us as important stakeholders in the implementation of law. I would conclude by thanking the Department of Legal Affairs and the Union Minister for having so graciously invited me for this. I spoke at the CBI annual lecture just the other day. The director of CBI had invited me and I spoke on a similar topic. I think that fueled the invitation to this particular morning's conference. I'm thankful to you for inviting me and only want to assure all of you that in tandem with all the steps which you will be taken, the judiciary, which I represent as the head of the family, is equally alive to its responsibilities, and we are in the process of discharging our own responsibilities to make these laws a success. Thank you.